Federal marshals just initiated operations at Trump Tower in Manhattan. A total of $540 million in judgments are now actively being enforced, with asset seizure protocols deployed at multiple Trump properties across New York. And this isn't some symbolic legal filing or distant court order. This is the United States Marshal Service conducting pre-seizure assessments of physical assets worth over $500 million. When federal law enforcement starts surveying penthouse floors, cataloging artwork, and photographing luxury fixtures with asset tags, you know the legal system has shifted from threatening to executing. Hit that subscribe button right now because you won't want to miss any of the videos I release. So what set off this unprecedented enforcement action? A federal appeals court on January 14th flatly rejected Trump's emergency motion to halt collection proceedings while he appeals the judgment. The three-judge panel issued a one-page order stating the stay request failed to demonstrate irreparable harm or likelihood of success on appeal. This isn't just another legal setback in a long series of court battles. Members of Trump's own legal team are reportedly expressing serious concern that physical asset seizures could begin within weeks, not months. And believe me, when marshals arrive with inventory specialists and forensic accountants in tow, you know something catastrophic has just materialized. Here's the full picture of what's been unfolding. Tensions between Trump's legal team and New York Attorney General Letitia James have been escalating for 18 months, fueled by repeated delays, failed appeals, and increasingly aggressive enforcement threats from the AG's office. But everything changed according to court documents filed December 28th, when Judge Arthur Engoron signed an enforcement order authorizing the Attorney General to proceed with collection activities including property liens, bank account freezes, and asset seizures to satisfy the $454 million civil fraud judgment plus accumulated interest, now totaling $540 million. The order, dated December 21st and made public a week later, explicitly granted James's office authority to coordinate with federal marshals for property access and assessment. This wasn't about policy debates over business valuations or accounting practices. It was about converting paper judgments into physical asset control. Smash that like button if this is making sense so far. Here's where it really gets serious. When attorneys from the AG's office presented the enforcement authorization to federal marshal coordinators in a secure facility in Lower Manhattan, they recognized immediately that this crossed from theoretical legal victory to practical asset liquidation. And let's be honest for a moment. Federal marshal involvement in civil judgment enforcement against a former president is extraordinarily rare. It doesn't happen over routine debt collection or standard business disputes. It happens when a defendant has exhausted appeals, demonstrated unwillingness to comply voluntarily, and holds assets substantial enough to justify federal coordination. Here's what multiple sources close to the enforcement proceedings say happened next. On January 3rd, a 6-person assessment team, including 2 deputy U.S. marshals, 3 forensic property appraisers, and 1 attorney from the AG's office, conducted a preliminary survey of Trump Tower's commercial floors. The team spent approximately 4 hours documenting high-value assets, including original artwork, custom fixtures, and architectural elements with potential resale value. Sources told Bloomberg Law that one deputy marshal was overheard explaining to building security that the assessment was authorized under Federal Rule of Civil Procedure 69, which governs enforcement of federal judgments. Meanwhile, attorneys for Trump filed an emergency petition with the Second Circuit Court of Appeals on January 6th, seeking an immediate administrative stay. The 47-page filing argued that irreparable harm would result from allowing asset assessments to continue while appellate review was pending. By January 14th, the 3-judge panel had unanimously rejected the stay request in a terse order stating that Trump failed to demonstrate a likelihood of success on the merits, or that the balance of equities favored halting enforcement. The order's language was unusually direct. It stated that delaying enforcement would reward dilatory tactics and undermine the court's authority to ensure compliance with judgments. Legal observers noted the panel's emphasis on Trump's pattern of using appeals to delay satisfaction of judgments he has the financial capacity to pay. Drop a comment right now if you saw this coming. I read every single one. Now things get absolutely unprecedented. On January 17th, deputy marshals returned to Trump Tower with expanded documentation authority. Sources present in the building that day describe a methodical operation lasting over 6 hours. Teams photographed and cataloged items on the 26th floor penthouse level, including custom gold-plated fixtures, museum-quality paintings, and bespoke furniture pieces. One appraiser was observed using specialized equipment to verify the authenticity of a Renoir painting displayed in the residence's main gallery. Security personnel employed by the Trump Organization were instructed to provide access to all areas specified in the court order. According to witnesses, building managers initially hesitated when marshals requested access to secure storage areas, but compliance followed after the lead marshal read portions of the enforcement order aloud, specifically citing the court's language authorizing entry with reasonable notice. That's when it became clear this isn't just another routine judgment enforcement. The level of federal coordination, the presence of specialized art appraisers, and the systematic documentation of high-value personal property all indicate preparation for potential forced liquidation. When U.S. Marshals photograph your artwork with case numbers visible in each shot, that's not assessment, that's pre-seizure inventory. This move sent shockwaves through Trump's inner circle. Multiple reports indicate emergency meetings were convened with financial advisors to explore options for satisfying the judgment without surrendering trophy assets like Trump Tower units. When a defendant who has spent months claiming inability to secure an appeal bond suddenly starts consulting with asset liquidation specialists, it signals the difference between legal posturing and facing actual enforcement. This isn't the first time a prominent figure has faced aggressive judgment enforcement after exhausting appeals. Think back to Bernie Madoff's victims seeking restitution in 2009. Federal marshals coordinated with bankruptcy trustees to inventory and seize luxury assets from Madoff's properties, including his Manhattan penthouse. Marshal teams spent days cataloging everything from artwork to vintage watches. The systematic approach established precedent for high-value judgment enforcement against defendants attempting to shield assets through legal delays. The properties were ultimately sold at auction, with proceeds distributed to victims. Then there was the Enron executives in the early 2000s. As civil judgments mounted against former CFO Andrew Fastow and others, federal authorities obtained court orders allowing property assessments. Fastow initially resisted cooperation, claiming ongoing appeals justified delaying enforcement. A federal judge rejected those arguments and authorized Marshal access to residences. The coordinated enforcement effort ultimately recovered millions for defrauded investors and pension funds. The key difference in that case was Fastow eventually negotiated a settlement that avoided forced auction of personal residences in exchange for cooperating with broader restitution efforts. Subscribe immediately if you haven't yet. This content doesn't exist anywhere else. And let's not forget Trump's own history with judgment enforcement. During his casino bankruptcy proceedings in Atlantic City, creditors obtained authorization for property assessments at Trump properties. However, bankruptcy protections and structured negotiations allowed Trump to retain control of certain assets while reorganizing debts. Now, however, it's different. This time, there's no bankruptcy protection, no automatic stay halting enforcement, and a judgment creditor with explicit authorization to proceed with seizures. The pattern is clear. When high net worth defendants exhaust legal delays and face determined creditors with court backing, even trophy properties eventually become subject to forced liquidation. So what specifically triggered this unprecedented federal involvement? According to legal and asset recovery experts who reviewed the enforcement order and subsequent marshal activities, the Attorney General's office demonstrated Trump's pattern of using legal procedures to delay payment while maintaining substantial unencumbered assets. The court's enforcement authorization explicitly cited evidence that Trump controls liquid assets and valuable real property sufficient to satisfy the judgment, but has chosen to pursue appeals rather than post a bond or negotiate payment. Court filings reveal the Attorney General's office presented evidence showing Trump's financial disclosures claiming inability to secure a $454 million appeal bond were contradicted by his own prior statements about net worth exceeding $10 billion. The judge found this discrepancy sufficient to justify authorizing aggressive enforcement measures designed to prevent dissipation of assets during appeals. Here's the kicker. The Marshal operations aren't limited to Trump Tower. Sources familiar with the enforcement planning indicate similar assessment activities are scheduled for Trump's Westchester Golf Club, 40 Wall Street office building, and potentially Trump's Seven Springs estate. This wasn't a single property inspection. It was the opening phase of a coordinated multi-property enforcement campaign designed to identify and secure assets totaling over $500 million. Don't go anywhere. The most explosive part is coming next. And here's what should alarm everyone following this case. This isn't just about satisfying one civil fraud judgment. If enforcement succeeds in seizing and liquidating Trump properties to satisfy the New York judgment, it establishes precedent for similar actions on other pending judgments, including the E. Jean Carroll defamation awards totaling another $88 million. Once federal marshals successfully execute enforcement on one judgment, additional creditors will immediately seek similar authorizations. The legal floodgates would open. This puts Trump and his legal team in a nearly impossible position. On one side, they face pressure from core supporters who expect continued legal resistance and defiant refusal to cooperate with what's characterized as politically motivated persecution. That means denouncing the enforcement as illegitimate, attacking the attorney general, and framing Marshal operations as government overreach. On the other side, they must reckon with the reality that federal law enforcement is now physically present in Trump properties, systematically documenting assets, and preparing for potential forced sales. They now have to explain how resisting enforcement serves Trump's interests, when cooperation could potentially preserve some control over which assets are liquidated and how sales are conducted. And here's the tricky part. There's no credible legal defense left. Either Trump has the financial capacity to post an appeal bond or satisfy the judgment, in which case his claims of inability are demonstrably false and the court is justified in authorizing aggressive enforcement, or Trump genuinely lacks access to sufficient liquid assets, which contradicts decades of his own statements about his net worth and suggests his business empire is far less valuable than publicly represented. Neither option provides a defensible position. Legal and political analysts are calling this a fundamental test of whether judgment enforcement applies equally regardless of the defendant's status or political prominence. Harvard law professor and former federal prosecutor Alex Whiting told CNN that if Trump successfully delays enforcement indefinitely despite clear court authorization, it would undermine confidence in the civil justice system's ability to hold powerful defendants accountable. He explained that the law provides no exemption from judgment enforcement for former presidents or political figures, and allowing Trump to shield assets through delays would create a dangerous precedent. Joyce Vance, former U.S. Attorney for the Northern District of Alabama and current MSNBC legal analyst, noted that Marshal involvement signals the court's determination to prevent Trump from dissipating assets or using appeals as an indefinite shield against enforcement. She emphasized that federal courts have inherent authority to ensure their judgments are satisfied and can authorize increasingly aggressive enforcement measures when defendants demonstrate unwillingness to comply voluntarily. Do me a favor and slam that like button because it genuinely helps this video reach more people. Even Andrew McCarthy, a conservative legal commentator and former federal prosecutor who has frequently defended Trump in legal matters, acknowledged that the enforcement actions are legally justified under the circumstances. He emphasized that while he disagrees with the underlying fraud judgment, courts have clear authority to enforce final judgments, and Trump's failure to post a bond or demonstrate genuine inability to pay leaves the court little choice but to authorize asset seizures. So let's break down what this could mean. First, the immediate financial impact is staggering. If marshals proceed to seizure and forced auction of Trump properties, industry experts estimate Trump could lose properties worth over $600 million in forced sales that typically yield 60–70% of market value. A distressed sale of Trump Tower commercial units could net perhaps $400 million, while Seven Springs Estate might sell for $20–25 million in a rushed auction environment. The differential between voluntary negotiated sales and forced liquidation could cost Trump over $200 million beyond the judgment itself. Second, the reputational damage compounds the financial losses. Trump has built his public identity around being a successful real estate mogul who never loses control of properties. Federal marshals placing seizure notices on Trump Tower, photographing the property for auction catalogs, and ultimately removing Trump's name from buildings represents not just financial loss, but a public dismantling of the Trump brand's core mythology. For someone who has spent decades cultivating an image of invincible business success, forced property liquidation represents a humiliating reversal. Finally, the legal precedent extends far beyond this single judgment. If New York successfully executes enforcement through federal marshals despite Trump's appeals and political prominence, it sends an unmistakable message to judges overseeing other cases against Trump. Courts considering similar enforcement requests in the E. Jean Carroll cases, other civil fraud matters, or business disputes will see that aggressive enforcement can succeed despite Trump's typical delay tactics. It shifts the calculation for judges from whether to authorize enforcement to how quickly enforcement should proceed. Drop a comment below with your thoughts. I'm genuinely curious to see your perspective on whether equal enforcement applies regardless of political status. But beyond the immediate financial and reputational consequences, this is really about whether the civil justice system can function when defendants possess both substantial assets and political prominence. The fundamental principle underlying judgment enforcement is that court orders must have meaning beyond words on paper. When a court determines through extensive proceedings that a defendant committed fraud causing measurable harm and owes specific financial restitution, The legal system's legitimacy depends on the ability to collect that judgment. If wealthy, politically connected defendants can indefinitely shield assets through appeals while maintaining luxury lifestyles, it creates a two-tiered system where judgments are enforceable against ordinary defendants, but merely advisory against the powerful. Judge Engoron's enforcement order explicitly addressed this principle. His authorization language stated that allowing further delay would undermine the court's authority and create an appearance that well-connected defendants can ignore judgments through endless appeals. The order emphasized that Trump had adequate opportunity to post an appeal bond or demonstrate genuine inability to pay, and his failure to do either justified immediate enforcement measures. This scenario is causing absolute panic within Trump's financial and legal teams. Reports from multiple sources indicate Trump's CFO and general counsel held emergency conference calls on January 18th with wealth management advisors to explore options for rapidly securing funds to satisfy at least a portion of the judgment. Some advisors reportedly argued for negotiating a structured payment plan with the Attorney General's office, emphasizing that cooperation could prevent the public spectacle of Marshal-conducted property auctions. Others insisted that any cooperation would be perceived as weakness by Trump's political base and could undermine his narrative of being persecuted by politicized prosecutors. The organization is fracturing in real time, torn between legal realism that recognizes enforcement is proceeding regardless of political optics and political loyalty that demands continued defiance regardless of legal consequences. Sources describe tense conversations where financial advisors present stark projections of asset losses from forced sales, while political advisors dismiss those concerns as capitulation to political enemies. Meanwhile, Trump's core supporters are expressing fury at what they characterize as government overreach and politically motivated asset seizure. Social media platforms are flooded with claims that the enforcement represents a coup, weaponization of the justice system, and persecution of political opponents. Conservative commentators are drawing parallels to authoritarian regimes seizing opposition leaders' property. The narrative frames Trump as a victim of a corrupt system rather than a defendant subject to standard judgment enforcement procedures. Things escalated further when Trump himself responded with a series of Truth Social posts on January 20th. He called the Marshal operations a witch hunt and a disgrace orchestrated by crooked prosecutors and corrupt judges trying to destroy him financially because they couldn't defeat him politically. He claimed the judgment was based on fabricated evidence and rigged proceedings, specifically attacking Judge Engoron as a Trump-hating activist who ignored overwhelming evidence of no fraud or victims. The posts characterized the enforcement as government tyranny and called on supporters to recognize the broader pattern of political persecution. Stay with me. What comes next will completely change how you view this entire situation. Here's what makes Trump's response even more legally damaging. His social media attacks on Judge Engoron and the enforcement proceedings provide additional justification for aggressive enforcement measures. Federal judges reviewing Trump's appeals will see his public statements attacking the legitimacy of court orders as evidence of a defendant unwilling to comply with judicial authority. When your public posture is that the judgment is illegitimate and the court is corrupt, you eliminate any basis for asking that same court for procedural courtesies like extended deadlines or negotiated enforcement terms. Legal experts immediately flagged this strategic blunder. Barbara McQuaid, former U.S. Attorney for the Eastern District of Michigan and current University of Michigan law professor, told MSNBC that Trump's attacks on the judge actively harm his legal position. She explained that appellate courts consider whether trial judges acted reasonably given the defendant's conduct, and evidence of the defendant publicly attacking the court's legitimacy makes aggressive enforcement measures appear more justified, not less. A defendant claiming persecution while simultaneously attacking the presiding judge destroys any appearance of good faith compliance with legal processes. This goes far beyond satisfying one civil fraud judgment. It's about whether American courts can enforce civil judgments against politically prominent defendants who command loyal supporters, willing to characterize all legal accountability as political persecution. If Trump successfully delays enforcement indefinitely by framing compliance as capitulation to political enemies, it establishes a roadmap for future politically connected defendants to evade judgment enforcement through public relations campaigns rather than legal arguments. If there are no consequences for refusing to comply with final court judgments after exhausting appeals, it fundamentally undermines the civil justice system's ability to provide meaningful remedies. The question becomes whether courts have practical authority beyond issuing orders, or whether defendants with sufficient political support and media platforms can simply refuse enforcement until public attention moves elsewhere. If this analysis is blowing your mind, hit that like button right now because the algorithm determines who sees this coverage. Here's the current situation. Federal marshals have conducted multiple days of asset assessments at Trump's flagship Manhattan property as part of enforcing a $540 million judgment. The Attorney General has explicit court authorization to proceed with seizures. Trump has exhausted his immediate legal options to halt enforcement, with the Second Circuit flatly rejecting his emergency stay request. This is no longer theoretical legal maneuvering or distant appeals. It's U.S. Marshals physically present in Trump properties, photographing assets, consulting with appraisers, and preparing for potential forced liquidation. When federal law enforcement begins systematic documentation of a defendant's luxury properties with case file numbers attached to each photograph, we've entered genuinely unprecedented territory for a former president. No prior president has faced federal marshal-coordinated asset seizure operations to satisfy civil fraud judgments. If there are no consequences and Trump somehow successfully delays enforcement indefinitely despite court authorization and marshal presence, it sets a catastrophic precedent. It signals that sufficiently prominent defendants with loyal political bases can functionally ignore civil court judgments by framing enforcement as political persecution. Every future high-profile defendant facing judgment enforcement will adopt identical tactics, claiming political motivation and rallying supporters to characterize standard legal processes as government overreach. Keep a close eye on this developing situation. More marshal assessment operations are reportedly scheduled for Trump's Westchester golf property and 40 Wall Street office building in the coming weeks. The Attorney General's office has indicated willingness to negotiate a structured payment plan, but only if Trump demonstrates good faith by ceasing public attacks on the court and presenting credible financial disclosures. Trump's legal team faces an imminent deadline on February 1st to file opposition to the Attorney General's motion for supplemental enforcement authority that would expand marshal access to additional properties and financial accounts. And military families, business owners who've dealt with their own judgment enforcement, and Americans who believe in equal application of law across the political spectrum are watching closely to see whether courts can enforce their orders against a former president who frames compliance as political surrender. Before we go any further, smash that subscribe button so you never miss content covering these constitutional enforcement questions as they develop. Here's where things stand right now. A total of $540 million in civil fraud judgments are being actively enforced through U.S. Marshal-coordinated property assessments at multiple Trump properties. Federal appellate courts have rejected Trump's attempts to halt enforcement during appeals. The Attorney General has authorization to proceed with property seizures if Trump continues refusing to post an appeal bond or satisfy the judgment voluntarily. Trump's public response has been defiant attacks on the judge and the proceedings rather than legal compliance or good faith negotiation. This isn't just another news cycle about Trump's legal problems that will fade as attention shifts elsewhere. This is federal law enforcement physically present in Trump properties, systematically documenting assets for potential forced sale, with explicit court authorization to proceed regardless of Trump's political status or public relations campaigns. What happens over the next 30 to 60 days could determine whether civil court judgments have practical meaning when defendants are politically prominent, or whether sufficient public support and media attention can functionally nullify judicial authority. The evidence is documented in court filings and marshal operations reports. The enforcement authorization has been issued. Federal appellate courts have declined to intervene. Now we wait to see whether the American legal system can enforce a $500 million judgment against a former president who characterizes compliance as political capitulation, or whether political prominence creates a de facto immunity from civil judgment enforcement regardless of what courts order. The stakes have never been more fundamental, the enforcement operations have never been more advanced, and the constitutional question of whether courts can enforce judgments against politically prominent defendants has never been tested more directly. Pause for a second and hit that like button if you're finding value in this constitutional law coverage and want to see the algorithm push this analysis to more viewers who need to understand what's unfolding.